This is the Hidden Killers Podcast with Tony Bruschi and continuing coverage of the case against Bryan Kohberger.
You know that moment, that very specific moment when someone gets caught red-handed and suddenly develops an elaborate explanation for why everything is actually someone else's fault? There's a lot of cases like that right now. I can think of Karen Reed. I can also think of Bryan Kohberger, where this case, you have a defense that has transformed a straightforward murder prosecution into what they're dramatically calling a constitutional crisis. But what looks more like standard defense attorney theatrics when your client's case isn't looking particularly strong. Over the past 2 weeks, we've watched Kohberger's legal team demonstrate the time-honored tradition of what's affectionately called throwing everything at the wall to see what sticks, turning an NBC Dateline episode into grounds for delaying justice, and spinning routine pretrial publicity into claims of fundamental unfairness that would make seasoned prosecutors roll their eyes. And Tony Bruschi, welcome. Please, in the comment section, let me know what your thoughts are on where this case is going, where this case is right now as we await that hearing here coming up in mid-June. We're kind of at a standstill, kind of doing a little reflection here on everything that has been going down and what some of these motions mean that have transpired over the last handful of weeks. The central drama revolves around Judge Steven Hippler dealing with an information leak to NBC's Dateline that aired on May 9th. The broadcast featured records from Kohberger's phone, including internet searches, Amazon purchase histories, Instagram photos, and cell phone tower data. Now, was this leak problematic? Yeah. Absolutely. The judge doesn't like it. Does it constitute the defense apocalypse that they're claiming? That's where things get interesting and where we need to separate legal maneuvering from actual procedural problems. Hippler responded by ordering both sides to preserve records and identities of who might have had access to leaked information. His language about wanting to find anyone who leaked to news organizations or anyone else suggests he's taking this seriously. But judges investigate information breaches regularly, keep in mind, without trails or trials grinding to a halt. The fact that he immediately moved to preserve evidence and identify sources shows a judge who knows how to handle media without accepting defense claims that the sky is falling. What's particularly telling is how quickly the defense pivoted from damage control to opportunity. On May 21st, they filed a motion to delay the August trial, arguing that the Dateline special created such a toxic media environment that fair proceedings are now impossible. The motion reads like a greatest hits compilation of defense arguments, complete with references to constitutional violations and systematic information failures. The defense claims this creates a pretrial publicity paradox, a PPP for short, because the show emphasized how secret the information was while broadcasting it. But here's the reality. Competent prosecutors deal with pretrial publicity constantly. The legal system has developed robust mechanisms over decades specifically to address these concerns. Voir dire questioning allows attorneys to identify and exclude jurors who've been influenced by media coverage, and jury instructions provide clear guidance about what evidence to consider. The motion also references an upcoming book scheduled for release mid-July, suggesting this represents part of a broader pattern of information violations. However, this argument lacks foundation. Books about high-profile cases get written constantly, often based on publicity available that's out there, public available court documents, media reports, and independent journalism. The mere existence of a book doesn't prove gag order violations any more than the existence of true crime documentaries proves procedural misconduct. The defense's alternative perpetrator theory represents perhaps the most ambitious aspect of their strategy thus far. They've submitted what's called an order of proof regarding an alternative perpetrator, which Judge Hippler immediately sealed. More significantly, he demanded that they provide whatever actual evidence you have that supports those allegations rather than just allegations by May 23rd. Just this judicial response tells us everything we need to know about the court's initial assertion of these claims. Alternative perpetrator defenses face enormous evidentiary hurdles in capital cases. Courts require concrete evidence pointing towards specific individuals with means, motive, and opportunity, not just theories about how crimes might have occurred differently. The defense claims they have evidence suggesting two people committed the murders using multiple weapons, directly contradicting the prosecution's singular perpetrator narrative. They also indicate they're pursuing leads buried in thousands of investigative tips. The timing creates what the defense wants to be characterizing as a procedural crisis, but what actually reflects here is normal capital case management. With jury selection starting July 30th and the trial beginning August 11th, Hippler scheduled that June 18th hearing specifically for the alternative perpetrator evidence, which should be good. This prevents trials from getting derailed by surprise theories during proceedings. It's judicial administration, not crisis management. Judge Hippler's inquiry about plea deal status provides perhaps the most revealing insight into the case's trajectory when he requested that the defense provide a declaration about any plea offers by late June or July. He was essentially asking whether negotiated resolution remains possible. This suggests recognition that the case is possibly headed toward conviction, with the real question being whether there's any path to avoid the penalty phase. The actual evidence driving these defense maneuvers deserves careful examination. Court documents, unsealed in March, revealed that Kohberger allegedly purchased that K-bar knife sheath and sharpener on Amazon approximately 8 months before the murders occurred. This timeline suggests premeditation rather than impulsive action. Prosecutors argued this purchase history, combined with DNA evidence, allegedly links him to a knife sheath found at the crime scene. It creates a compelling narrative of deliberate preparation. The prosecution possesses what they described as a selfie photograph allegedly taken by Kohberger hours after the killing, showing facial features, particularly bushy eyebrows, that match descriptions provided by surviving roommates. While defense attorneys will challenge visual identification reliability, the evidence creates temporal connections that extend beyond the physical crime scene. The DNA evidence represents the prosecution's strongest asset. The knife sheath allegedly found at the crime scene reportedly contains what prosecution calls a statistical match to Kohberger's DNA. When combined with the Amazon purchase showing him buying the exact knife type and sheath months earlier, creates a physical evidence chain connecting preparation to execution to post-crime behavior. And the autism spectrum disorder diagnosis introduces complexity that cuts both ways for the defense, leads to the defense attorney, Ann Taylor, has noted that Kohberger's flat affect, piercing stare, stiffness, holding still during emotional testimony reflects his disability rather than callousness. However, this argument assumes jurors will interpret his behavior negatively in the first place and suggests the defense anticipates their client won't present well during proceedings. You think? Judge Hippler's ruling that the autism diagnosis doesn't preclude death penalty eligibility follows established legal precedent. Courts reject categorical explanations or exemptions based on disabilities unless there's clear Supreme Court guidance. The defense argument that jurors need this information during the guilt phase rather than just penalty phase suggests they're already planning damage control strategies. If the venue changed as well from Moscow to Boise, it demonstrates that courts possess effective tools for addressing pretrial publicity. This relocation was granted specifically to ensure impartial jury selection, proving The judicial system has mechanisms for handling media attention without accepting claims that fair trials become impossible. The successful, vague challenge undermines defense arguments about media contamination making proceedings impossible. Trial logistics reveal normal capital case complexity rather than exceptional circumstances. Hippler ruled proceedings will be live-streamed with cameras focused on specific areas, but without production elements. He agreed to shut down streaming when surviving roommates testify, balancing transparency with witness protection. The schedule extended through November 7th. Reflects typical capital case duration, not media-induced complications. The discovery volume, over 9,000 investigative tips and extensive evidence processing, indicates through police work rather than investigative failures that they did their job. The prosecution reports being more than 95% finished with evidence processing and has provided Kohberger's team with virtually everything except materials with protective orders. The completion level suggests prosecutors are confident in their evidence foundation and at least they're ready for trial. Family attendance procedures provide additional insight into normal judicial management. Kohberger's parents and sisters want to attend trial, but prosecutors indicated that they might call some family members as witnesses. Hippler ruled that family members can remain throughout trial, regardless of witness status, reflecting recognition that capital defendants need emotional support while maintaining appropriate procedural safeguards. The investigation's scope and methodology reveal interesting details about law enforcement's approach. The defense team reportedly claims evidence suggesting multiple perpetrators using different weapons. But this theory faces significant challenges. If law enforcement had credible evidence pointing towards other suspects, it would have emerged during the extensive investigation that led to Kohberger's arrest. The defense claims about pursuing leads and thousands of tips suggests they're searching for alternative theories rather than processing concrete evidence. Idaho's capital punishment procedure adds another layer of context. Idaho maintains the death penalty and has excluded defendants in recent years, making this a genuine capital case rather than a symbolic prosecution. The state's willingness to seek death in appropriate cases means prosecutors wouldn't file capital charges without confidence in their evidence. This context makes the defense delay tactics more understandable. They're facing genuine consequences rather than just theoretical penalties. The prosecution's confidence becomes apparent through their actions and statements. They've indicated readiness to proceed with the August trial date despite defense motions for delay. They've completed evidence processing and discovery production ahead of schedule. And most significantly, they've maintained their capital prosecution despite defense challenges and media complications. It suggests they believe their evidence can withstand scrutiny and persuade juries beyond a reasonable doubt. Obviously, the media environment around this case is intense, but it doesn't approach levels that have actually derailed major prosecutions. High-profile cases like O.J. Simpson to Casey Anthony to Derek Chauvin have proceeded to verdict despite massive media coverage. Courts have developed sophisticated jury selection procedures specifically to identify and address pretrial publicity concerns. The notion that media coverage makes fair trials impossible would essentially end high-profile prosecutions entirely. Good luck with that. Defense attorney Ann Taylor's reputation and experience provide context for understanding their strategic choices as well. Taylor has handled multiple capital cases and understands the challenges of defending against strong physical evidence. Her decision to advance alternative perpetrator theories and constitutional challenges suggest recognition that conventional defense strategies may be insufficient given the evidence arrayed against her client. The technological aspects of the investigation reveal modern law enforcement capabilities that create challenges for the defense team. Cell phone tower data, Amazon purchase histories, and DNA analysis provide evidence trails that did not exist in earlier eras of criminal prosecution. These technological tools make it increasingly difficult for defendants to escape physical connections to crime scenes and preparation activities. The upcoming June 18th hearing is going to likely resolve the alternative perpetrator question definitively. If the defense produces compelling evidence pointing towards other suspects, it could fundamentally alter the case trajectory. More likely, given judicial skepticism and evidentiary requirements, the court will likely reject these theories for insufficient foundation. The hearing represents a critical juncture where legal theories meet evidentiary reality. Judge Hippler's case management style emerges through his decisions in scheduling. His demand for concrete evidence rather than speculative theories reflects judicial efficiency and skepticism of unfounded claims. His investigation of information leaks demonstrates appropriate oversight, accepting defense characterizations of procedural breakdowns. His scheduling of hearings and deadline shows a jurist moving the case towards resolution rather than indefinite delays. The prosecution's evidence timeline creates a compelling narrative of premeditation and execution. Kohberger's alleged Amazon purchase 8 months before the murder suggests long-term planning rather than spontaneous violence. The DNA evidence at the crime scene provides physical presence confirmation. The post-crime selfie photograph creates behavioral evidence of consciousness of guilt. This timeline challenges any defense theory of mistaken identity or alternative perpetrators. What ends up emerging is a capital case proceeding through established legal procedures despite defense efforts to characterize routine challenges as unprecedented crises. The information leak was problematic but manageable through existing judicial mechanisms. The alternative perpetrator claim, it sounds dramatic, but likely lacks any sort of evidentiary substance. The autism diagnosis arguments reflect strategic preparation rather than legitimate grounds for special treatment. As we approach the critical June and July deadlines, the most probable outcome involves defense motions being denied, alternative perpetrator claims being rejected, and the case proceeding to trial where prosecutors present their evidence and juries decide guilt based on facts rather than legal theater. The August trial date will likely hold. Jury selection will likely proceed despite media coverage, and we'll discover whether the prosecution's evidence is as compelling as they believe it to be. Tell me what you think in the comments about this case, where it's heading. We are literally in June right now as we are recording this. We are not far away from that hearing. We are not far away from actual jury selection beginning. We're also not far away from the 3-month anniversary of this tragedy, or 3-year, rather, anniversary of this tragedy. Again, curious to get your thoughts in the comments. Be sure to press subscribe wherever you're listening to this podcast. If that's what you're doing, if you're watching us on YouTube or X, again, please hit subscribe and let us know what you're thinking. My name is Tony Bruschi. Thank you so much for listening. We will talk again real soon.
Craving non-stop true crime updates? Press subscribe now and get the latest cases, analysis, and expert commentary delivered straight to your feed. Only from the Hidden Killers podcast and True Crime Today.